Hello everybody, very warm welcome to this last regulatory and compliance update for 2025. It has been a fairly quiet month, so I'm not going to keep you as long as I normally do, but don't see that as a false sense of security. I think 2026 is going to be quite a year for us, as you'll see as we go through. I did have some feedback on the new slides that we've adopted. And hopefully you'll see that I've actually increased the size of the slides so you can read them better. And I've also tried to reduce the amount of small print where appropriate. So hopefully you will find those far more user-friendly. For those of you who are joining us for the first time, if you do have any questions, if you want to put those on the system, and I'll pick those up at the very end. If you're a solicitor, it's A2 for competency purposes. We are recording the session, so that will be made available. Slides I've already put on the system, so if you want to pick those up and watch as I go through, then please do. I've been doing a lot of activity on LinkedIn as usual, so if you aren't already connected with me, then please do send me a request and I'll approve that or accept the invitation with pleasure. And what I also do is put the links at the bottom of the slide so that you can see further detail if you want to. And don't forget to click Save a Seat to register for future webinars. While we're talking webinars, just so that you are aware, the next regulatory and compliance update, it would normally be held on the first Thursday of each month, but of course next month that is going to be the 1st of January. Well, of course, I think we're all going to be enjoying ourselves on the 1st of January, so we have moved it to the 8th of January. We will be registering people onto the system, so don't worry about that. But just so that you've got your diary, it's now the 8th of January. Again, we do record, so it does go out on Bizzabo as an on-demand webinar. Also, it's on YouTube, and for those of you who have our learning management system, it's on there as well. So if you can't attend, then there are other ways of accessing it. We've got horizon scanning on the 15th of January. So myself and my colleague Almina, we're going to be going through what we are looking at in 2026. And as I said before, it's looking to be a very busy year. On top of that, of course, we've potentially got, I say potentially, I think it's a definite, we've got the post office scandal report coming out, which is going to look at the involvement of the lawyers. So I think we're going to see a lot of things coming on that. And I'll touch on that a little bit later on. We've also got one of our most popular updates, and that's the AML update on the 22nd of January. So make sure you are coming to that one, or certainly picking up the recording if you can't make it. Just so that you are aware, and again, I apologise for the small print, but in effect, this slide is for you to have a look at later on. But what we now have is an access policy and procedures app. So rather than having written documents, I mean, you can still have those if you are subscribing to those, but we also have an app as well, so people can carry it around on their phones. So if you are interested in that, then please do let us know and we'll give you further details. And would you like to take part in a course video on how to be a COFA? But we are basically revamping some of our courses, and how to be a COFA is one of them. If you are interested in participating in that from your firm's perspective, perhaps your thoughts on the SRA consultation. I know it's gone into slightly long grass, but I think it's going to be coming out fairly soon, perhaps in 2026. So, if you want to give your thoughts on that, then please email me if you are interested. Okay, so main event. We've seen some more. I asked a question on LinkedIn the other week. Are there any more fines coming? We obviously had the SRA's thematic review of AML and things like the normal annual thematic review. And I was wondering, it had gone fairly quiet. And now we're seeing things coming through. So £500,000 worth of fines levied to 46 firms. You can see there the common failures. Nothing changes really in relation to those. They're the same sort of list of issues that have been seen in previous cases. Excuse me. The CQS situation has got worse. So what we saw in June was 70% of firms fined for AML breaches held CQS, and it's now gone up to 76%. Speaks volumes about CQS, and certainly I'm pushing for the Law Society to have a look at this, because in effect, if you've got 3/4 of the firms fined who are holding CQS, which is supposed to be a quality scheme, you know, what does it say about the scheme if 3/4 of the firms aren't compliant? So I am pushing that, because of course there will be lots of firms out there that are being compliant with CQS, and is it fair that they're sort of on one level, on one playing field, and somebody is on another playing field? We need to have it level to make things fair, because of course they are getting a competitive edge, because in effect they're being able to hold themselves out to CQS when in fact they're not complying with CQS, and so, you know, they are getting the benefit from the CQS logo. So anyway, we'll see what happens with that one. Facilitating money laundering. This was a case which came up, I think it was this morning, I think. And it's something that I've been looking at over the years in terms of, well, we only seem to be seeing procedural breaches of money laundering requirements rather than actual money laundering, including the facilitating of money laundering. And so when I saw this, I thought, right, okay, well, this is clearly now moving on. So here we have a solicitor failed to spot red flags in a fairly large transaction. The judge basically said, by his the SDT, sorry, said, by his failings, Mr. Levy effectively facilitated transactions that bore hallmarks of fraud and or money laundering. £15,000 fine, £35,000 in costs, and a previous history, £5,000 fine in 2025. The SDT said where there were red flags, he should have asked the right questions. Well, clearly everybody should be asking the right questions. For those of you who are interested, that £5,000 fine in 2022 related to accounts breaches, but clearly there's a bit of a trend there in terms of not complying with the relevant regulations. So, yeah, I think this will be the first recent one, certainly. I can't remember the last one, but I'll say recently. Facilitating, I think we're going to see a lot more of that coming out in cases going forward, particularly when supervision is taken over by the Financial Conduct Authority. And no, we don't have a date on that yet, but I certainly am recommending to firms that they prepare for the FCA. Now, what the FCA have said, and I think I said this last month, is that as long as you are compliant with the regulation now, you shouldn't have a problem when they take over. Well, clearly, the previous slide shows that actually there are a lot of firms out there that are not compliant, and I think are only seeing the tip of the iceberg. I think there will be more firms out there who perhaps are pushing the boundaries on compliance and things like that. So people need to get their houses in order. Source of funds, well, we're continuing on the AML theme. So this is the report that came out from the SRA's review. So you can see they looked at just short of 6,000 files, 833 files inspected. And again, the sorts of issues that they're finding, and again, I just touched on, you know, firms not being compliant. Well, clearly we're seeing things not as they should be. 11% no source of funds checks at all. Then we've got 18% inadequate scrutiny of documents. There's no point just getting bank statements. You need to actually interrogate them. And I know I've used this case before, but I remember doing a review of a file, and there was the only source of funds check on there was a bank statement. And when I was looking at it, over £200,000 had been paid into this person's account. And I then actually thought, well, hang on a minute, this person is on benefits. Where's this £200,000 coming from? And it was only when I went back to the fee earner and said, well, where is this money coming from? Because it doesn't stack up with their background, that they then said that they had a girlfriend who was a high-flying banker, I think it was, who was contributing towards the property transaction. Well, that's fine, but why hadn't they asked that question? Why hadn't they written it down? Why weren't sort of, the pieces of the puzzle being put together to form that picture? So a bank statement on its own is not enough. You need to look at it. You need to ask questions. You need to be making notes. And I know I say this about firm-wide risk assessments, but again, I think the safest route is, even if you don't have anything to say, just put on the document or on your notes that you've looked at it, you haven't seen anything suspicious, and therefore you've moved on. I think to leave it as nothing, the SRA will say, well, you didn't review the document. Even if there was nothing there, it was showing that you didn't, in fact, review the document at all. So I think just putting that little statement on something would certainly help. And again, funds don't match the ledger records. So this is, making sure that monies that come in or being used for transactions do stack up with the whole transaction. But you can clearly see, there's a lot of firms there that have got questions that need answers. And those answers are, do the right thing, adopt the right policies, controls and procedures. Do it now before we get into the hands of the Financial Conduct Authority, who are known to be a far more robust regulator than the SRA. And if you thought the SRA was tough, well, certainly the FCA, as I understand it from people currently under the FCA regime, they see it as a very, very tough regime. And right at the bottom there, some of these firms, they've been non-compliant for 7 years. And compliance failures remain persistent and widespread. Well, we can see that, from the fact that I talked about 70% CQS firms non-compliant in June, and they've now risen to 76%, 6 months later. So clearly people are not picking up the hint that they need to be doing stuff. Threats against solicitors. So moving on to a completely different topic. This is something which the Law Society brought in or published. So you can see here there is a real threat to members of the legal sector for different reasons. Obviously, I've seen some things where lawyers who are acting for unsavory characters, if I can put it that way, are being picked on and things like that. The fact that you're doing your job, you are representing people as you should, and I say that with caution, because of course there are lawyers out there, as we've seen with the post office scandal, who have done the wrong thing. Yes, it's innocent until proven guilty, but based on the evidence that I've seen, there are lawyers out there who didn't do the right thing. So on the basis that you are doing the right thing, then you should be allowed to represent the clients that you want to represent. But obviously there are people out there who don't think you should be representing certain people. But what flows from this is not just we've got a threat out there, but we need to mitigate the risks of this. You have a duty to protect your staff. So, make sure that you're taking the appropriate steps to protect your staff. If you have any clients who are being abusive to your staff, then you need to address that. You can't just let it go and think, well, that's no problem. Even if they are your biggest source of income, you need to make sure that you deal with them. You have no choice with that. So what the Law Society says is the level of threats, intimidation, and even physical violence faced by solicitors has significantly increased and extends across a wide range of practice areas. Threats against solicitors were not isolated incidents. They are systemic and rising. Abuse, aggression, and intimidation towards solicitors is alarmingly commonplace. So, yeah, the Law Society clearly thinks there is an issue there, and certainly I would agree with them. So do make sure you reduce the risks to your staff. and make them aware of this particular issue so that they are prepared for it. Post Office Horizon scandal. So I mentioned that a moment ago. We now have a number of people under investigation. Yes, I've previously mentioned that the SRA is carrying out 20 live investigations, and we're now seeing the police getting even more on top of all of this. So there are 53 people of interest being looked at. But they're not just being looked at for the conduct within the scandal itself. They are now being looked at for corporate manslaughter because we've had to date 16 people commit suicide as a consequence of the scandal. So this is why I was saying earlier on, I think 2026, we are going to see a lot of stuff coming out around the post office scandal. I think we're going to see a number of prosecutions going forward with the SRA. I think it says they're charging decisions late 2027, but I think, we are going to be seeing a lot more movement around what the police are actually doing as well. So you can see at the very bottom there, they're looking at things like perjury, preventing the course of justice. But one of the questions which I've been asking on LinkedIn recently is, where are the money laundering charges in all of this? Because the £36 million plus that the Post Office defrauded from sub-postmasters is the proceeds of crime. So the Post Office has £36 million at least, and they've been using it to boost their profits, to boost salaries, to boost bonuses. Well, they've laundered money. You've only got to look at all the various sections of the Proceeds of Crime Act, and they fall squarely within that. Also, of course, you've got the lawyers who are involved. So the lawyers, were there reasonable suspicions that they should have reported? Well, if there weren't before 2019, okay, that's got to be, the questions there have got to be answered. But certainly when the court case found that the Post Office had been fraudulent in what it was doing, in 2019, have any of the law firms or the lawyers actually sought advice or sought a defence with the NCA to carry on working for the Post Office? So it's going to be really interesting, this one. Again, it's something which I'm sort of asking questions on LinkedIn about. There may be things going on in the background, but one would have thought that if there had been money laundering going on, and I suspect there has been, and reports have not been made, surely that is something that can be dealt with independent of all the conduct issues that have been going on within the Post Office. It seems to be, yes, it's linked, but it's actually something separate. So on the basis that there hasn't been any prosecutions or enforcement action taken purely looking at it from a money laundering perspective, suggests that there's no action. Well, one of the things I'm doing, having worked with the Post Office, the innocent sub-postmasters, is pushing to see whether in fact this can be put on the charge sheet. So it's one to watch. The Law Society special general meeting, SGM, threshold ballot. You will have received, if you're a solicitor, you will have received your ballot papers or via email or however they're sending it out. It's an interesting one, this, because the president called the membership ballot despite defeat. Council withdrew support at the special meeting, but the ballot must proceed anyway. Apparently the bylaws prevent withdrawal. And as you can see there, one of the council members said, it's a mess and totally unsatisfactory. I've looked at some of the figures here, and when you look at the fact that it's going from, or they're trying to get it going from 100 to over 1,000, that's a big difference to try and get over 1,000 people to sort of put forward a need for an SGM rather than 100. But I think the Law Society have got themselves really tied up in this. I would ask for your help. One of the things that I did yesterday, I think it was, or the day before, was I've put a poll on LinkedIn. And this is specifically for solicitors. And it's in effect asking, if you had a choice, would you still pay a membership fee to the law, to be a member of the Law Society? And I'm just trying to sort of get an insight into what people's thoughts are. I've already had quite a few where they basically said, no, I wouldn't. And so I'm just trying to sort of get a balance. So if you wouldn't mind and you've got time, then please do go on there and put your thoughts on the poll. UK cyber insurance, it continues to be a big risk. As you can see there, we've gone from £59 million worth of payouts to 197 million in 2024. Malware, ransomware attacks, 51% of claims. So it's certainly up massively. So have you got the right policies in place? Have you got the insurance in place? And more importantly, does the insurance actually cover you for all the various issues that go on around cyber? I've mentioned it before, but certainly when I started looking at cyber, when it first started coming, cyber insurance, when it first started coming out, I did find that, yes, it was covering sort of top level things. And when you started to look at the exemptions, it was then saying, well, actually, we're not going to cover this and we're not going to cover that. So do make sure you have a look at your policy on that. You'll see that there's no link on there, and that's because it was behind a media paywall. So you'd have to pay to get access for that. But hopefully that slide just gives you enough to, to make you think. Major insurers retreat from comprehensive AI coverage. Now, of course, there will be debate about, well, has anything to do with AI been led to negligence? Well, I suspect it would do. And therefore, the question is, well, if it's negligence, then surely it's covered under the PII insurance. Well, I think you need to ask the question of your insurers in terms of, if we are adopting AI, and there are risks, as you can see there, hallucinations, defamation, incorrect advice, systemic errors, who will pick up the tab for all of that? And if it is us as a law firm, does our policy actually cover it? So do have a look at that and make sure that you understand where the liability lays. And as you can see there, is it the software developers? Is it the AI model builders? Is it you, the law firm? So it's, it is good to have a look at this. Now, admittedly, when you look at the insurers, AIG, Great American, WR Berkeley, they are mainly based in the US. But of course, what happens in the US tends to find its way over here. And AIG certainly has business over here as well. So it's starting to creep over here. But I think that the big message is speak to your PII insurers and just make sure of their positioning around AI claims. And here we have a case. AI-generated fake cases, wasted costs order, but no SRA referral. So in effect, there was a thought that the SRA, having had the referral, with no referral, but if the SRA then got involved in this, that it would then be down to the individual. But actually, the judge is in effect saying it's not the individual solicitor's failure alone, it's the firm as well. Excuse me. So you can see there, in substance, it was a failure of management. So supervision, did they have the policies and controls in place? What was the sort of the principles behind the use of AI? So make sure that you do the right things from an AI perspective, because there are other issues going on as well. So the AI conveyancing challenge. So this is where we've seen cases of clients, and it's not just conveyancing, although that was the main thrust of this one. We have had some firms contact us saying that basically they have had clients walking in, having done a search on ChatGPT or whatever other system they've been using, and saying, right, well, this is what ChatGPT has said. What are your answers to this? Well, again, you need to have a good understanding of what your own policy is if you are using AI, or if you don't want to get involved in AI, particularly when it's clients presenting you with documents. It may be that actually what they've done is they've thrown your letters of advice or whatever it might be into ChatGPT, and they've then come back to you to say, well, actually, I don't agree with your advice because ChatGPT, or whatever the system is, says otherwise. So what are you going to do about it? So I think you need to have a policy in place that in effect says either we won't deal with, we will not deal with AI produced documents from clients, or we will, but the clients have to pay for it. Because of course you then have to take time to have a look at that document and then work out whether in fact it's telling the truth or not, as the case may be. It may be that actually ChatGPT or whatever system has found an error in what you're saying. So by turning around and saying, well, we're just not going to look at any AI reports from clients, you may actually be doing yourself a disfavor, because they may turn around if a claim for negligence is made at some point in the future and say, well, we did tell the firm, but they didn't want to know. So you need to have a good think about, well, what are you going to do with all of this? So put in your terms and conditions, certain things around the limitations and unreliability of AI-generated legal advice. And again, I would certainly be picking up the phone to professional indemnity insurers to say, we know this is a risk. What would you suggest? Because they're covering you. And of course, if you don't sort of ask their views and take their lead, then they could turn around and say, well, when a claim does come along, we're not going to cover it because. So just make sure that you've spoken with your insurers. Professional qualifications and regulatory obligations. So again, do you have, if you've got to act in the best interests of your client, and your client believes that you're not doing that, and they have produced an AI document, could you have an issue with that? And as I say, additional fees for addressing AI-generated challenges to advice. What happens if somebody comes with a couple of A4 pages of challenges from ChatGPT or whatever? Are you going to charge for that? And if so, have you told the clients you're going to do that? So we then move into the world of transparency and making sure that, things are on your websites, are on your terms and conditions and such like. So, yeah, I thought I'd put that one out there because as I've put in the red box there, it's a growing problem. Okay, the Legal Services Board, they have launched a new consumer protection program. I have to say, well, why haven't they launched it in the past? Particularly when you look at the key focus areas. Volume litigation, that's certainly something the SRA should have picked up in light of the SSB. So why is the LSB only picking it up now? You've got consolidator firms. Well, why wasn't that being picked up with Axiom, Int, and other consolidators before that then went out of business? And of course, we've then got unregulated providers. So they are certainly taking things by storm, particularly with the use of AI and online legal tools. So it will be interesting to see where this one goes, but it certainly gives you a feel for what sort of issues the LSB will be looking at in the new year. Companies' house identity verification. So yes, we've had the deadline 17 November. 5 million directors haven't basically verified, and that could include a number of your partners, if you're LLPs, companies, and all that sort of thing. So do make sure that you do verify, because as you can see there, after the deadline, unverified directors will be unable to access Companies House services, including filing accounts or updating company details. So how will you do that if you haven't done it? So, make sure all your partners, where appropriate, have verified their identities. Something which has changed on the 1st of December, the FSCS deposit protection. It was £85,000. It's now gone up to £120,000. and you've obviously got the 1.4 million temporary high balance protection for conveyancing cases as well. So do make sure that you've updated that. We have updated our template policies, so if you are subscribing to those, then that will already be updated for you. So just one to look at. CILEX, in terms of Mazur, CILEX has appealed to the Court of Appeal on this one. One has to ask why it's come to an appeal. Surely they should have been asking these questions a long time ago, but clearly they feel under a lot of pressure at the moment because they've seen job losses, business model changes, and court delays. So bearing in mind it's their members that are being caught up in this, one can understand why they are appealing. LLP budget proposals. So we've had the budget since last month, where I was talking about potentially LLP proposals coming in. They have not materialized, so you can sit back and relax. If you're an LLP, you won't be getting the additional taxes that we were talking about. So just wanted to update you on that one. House of Lords Constitution Committee. So this is the rule of law. You are likely to have to be doing a lot more mandatory ethics training. And this is already something that has been pushed by the SRA and the LSB, but it is quite clear it's taking the government, House of Lords and other parliamentarians by storm, because they believe there is almost no ethical training after qualification. I have to say, I don't think there is enough building up to qualification, let alone after. So I think this is going to be a massive issue. And again, I think we are going to see a lot of things coming out of the post office scandal around ethical conduct or unethical conduct, as I think we will find there's been. Urgent court delays. Well, of course, they're looking at the courts at the moment in terms of the number of cases that are in the backlog and things like that. We are obviously seeing a lot of issues at the moment around what the Lord Chancellor has done in terms of jury trials, and the fact that he's saying there will not be jury trials for cases where sentences are less than 3 years. It's going to be interesting to see what happens with this one when it gets to the Lords, I have to say, because if my memory serves me right, no, in fact, I'm thinking about something else. But yes, it's certainly being pushed by the Lord Chancellor. But as I say, I think when it gets to the Lords, it's going to come up for a lot of resistance. So we need to see what's happening there. MOJ report, Future of Legal Services, as it says, may look very different to the one we know today. And I think they are quite right. We will see different things. And I touched on them a moment ago with AI and technology and all these other things. They're going to be looking at reassessing reserved activities. Well, that's something Professor Stephen Mason's been looking at in his various reports over the years. And do they make sense in a digital world? But again, this is where we have the unreserved and unauthorized businesses basically getting in on the act. So will we see some of the current reserve services being opened up to these non-authorized organizations? Support for LawTech revolution. So again, they're wanting to sort of increase the use of LawTech to push things a lot faster. I think they need to be really, really careful on this one and make sure that everything is as it should be. There are a lot of groups that are sort of resisting this move. So again, it's going to be interesting to see what happens with that. I am liaising currently with the Justice Committee and others around the regulatory side of things. And so it's going to be interesting to see whether we do see any change in the regulatory landscape. But certainly when you look at the issues that we've got with the SRA, around Axiom, around Mazur, around SSB, when you look at the fact that we've got issues with the Bar Standards Board, we've got issues around whether CILEX is going to move into the SRA. We then have very small regulators who could be sort of, brought into a single regulator with no real problems at all. So it's going to be interesting to see where that one goes. But I think there's definitely need for a new legal services act. And whether it's 2006, 2007, 2008, I think we definitely need a new one to take into account what we're doing at the moment. Okay, disciplinary cases. I'm now sort of, because there seems to be so many, I've now picked sort of the top 5. So you can see we've got lawyers being struck off. We've got a lawyer, this was a head of litigation who wasn't a solicitor, who misled a client, but using the proceeds of crime as well. So I think this was someone who basically paid off their mortgage with proceeds of crime from their brother who'd been involved in different things. The one right at the very bottom there is worthy of a bit of mention. Solicitor suspended for 18 months, failing to check new employee background. So this is where they basically took on a dodgy employee because they didn't check on the records. Just a quick reminder that you do have a duty under the money laundering regulations to carry out screening of employees to make sure that they are the right people to take on in the first place. But of course, you then need to do ongoing screening as well. So you need to be checking on competence and whether they are in fact appropriate to be in a regulated entity covered by the money laundering regulations. So make sure that your checks are where they need to be. So compliance actions for you. I said it wasn't going to be as long as it normally is. But key compliance actions: ensure your AML policies, controls and procedures are compliant. Ensure employees are kept safe. Check your AI insurance position. Verify company's house if that applies to you. Update your FSCS limits in your terms of business as well. So there's a few things for you to be doing either before or during the Christmas break. Hopefully you won't be needing to do it during the Christmas break. You should be enjoying yourselves and taking a well-earned break. But certainly these are things that you need to be looking at. And so if you have any questions, and I haven't seen any on the system just yet, but if you have any questions, please do put them on the system. If you have got to shoot off, then thank you very much indeed for all your support this year. Have a wonderful holiday, and we'll see you in the new year. I've just had a question from Michael. Is there any update on the May 2025 SRA review of first-year complaints which were due to come into force in November? No, Michael, I've been looking out specifically for this one. I've been sort of deep diving into both the SRA's website and also the Legal Services Board's website to see whether in fact the LSB has approved those rules. I haven't seen anything as yet. So just hold fire on that one, unless anybody else who's on the session has actually seen anything, but I certainly haven't. Joshua has said, I think they extended to January the 11th. Okay, well, thanks for that, Joshua. I'll keep an eye out for that, and we'll see where we go with that. Margarita has said, it will be interesting to correlate the CQS firm AML fines against firms that also have Lexel, where the firm has an external assessor who arrives, let me just get more detail, on site once a year. Well, I have to say, Margarita, some of the CQS firms held Lexel as well. And that has been a trend on all the cases that I've seen over the years. And so Lexel seems to be just, well, I say just as bad. Certainly, they are just as bad in terms of the Lexel firms themselves not being compliant either with the rules or with the Lexel requirements. And both Lexel and CQS have to apply the core practice management standards. So it's across the piece. I have had some people who have said, well, Lexel and CQS don't apply the same standards in terms of AML as the rules. Yes, they do. They quite clearly do when you look at them. Whether they are in exactly the same wording, well, it still requires firm-wide risk assessments. It still requires client and matter risk assessments, policies, controls and procedures, and all the other things that go with it. And I think if you try to argue, that actually, well, it doesn't, I think you'll be onto a bit of a loser with that one. But certainly, I have to say I'm really disappointed with the Law Society, and I have raised my concerns over the years with the assessments on both CQS and LEXL. Now, one of the problems that you've got with LEXL is, as I understand it from LEXL assessors, is they are under extreme time constraints to keep costs down, and therefore they haven't got time to be going through everything that perhaps they should be going through. So I think potentially these assessments may give you a false sense of security. Do not take it for granted that just because you retain your CQS or your LEXL accreditations, that actually you are fully compliant with it. You need to be ticking the boxes, I hate that phrase, but you need to be checking to make sure that you are completely compliant with it. Now, one of the issues that I've raised with the Law Society is in terms of there is no deterrent. If there was a deterrent, then would we keep on seeing all these firms with accreditations not meeting their standards? No, I don't think we would. But the Law Society has basically said, in effect, unless it is a worst case scenario, they will not be withdrawing or suspending accreditations. They will work with firms to become compliant. My question is, well, where were you when you've got firms that have been non-compliant for up to 15 years? And they also defend themselves by saying, well, we've got all these, these processes in place that catch all these things. Then why have we seen in the last 6 months an increase of 6% of firms continuing to be found in breach of the money laundering regulations and them holding CQS as well? It doesn't seem to be working. So we'll see on that one. Anonymous has said, hi, in terms of source of funds checks, we have seen guidance of checking the sender of funds matches those we have undertaken our source of funds checks on. Is this simply the sender name? This is all the bank includes with payments, or would you suggest this extends to accounts teams requesting the bank send the sender bank details, sort and account details? Yeah, it's a difficult one, this, because of course the banks tend not to provide everything that you perhaps want. But what you need to be doing is taking as many steps as you need to satisfy yourselves that the funds are as they should be and they stack up with what the clients have told you. Now, again, in all the debate around reform of the money laundering regs and things like this, a lot of people say, well, hang on a minute, the banks are the key people who are checking where this money is coming from. Why can't we just trust the banks? Well, they don't seem to be wanting to move away from that position. So we have got to be, picking up the phone to the banks if necessary and asking them various details. Now, whether they provide it is a different matter. So you may then want to say, well, on your risk assessment, well, we contacted the bank, they wouldn't provide us with these details. Therefore, we have gone to the client and we've asked for further information to try and clarify the position. That's the sort of stuff that you need to be doing, unfortunately. Yes, it's more work, but when you've got previous heads of the National Crime Agency and also the NCA turning around and saying, do have to be policemen, well, you can see the sort of position that we've got there. Joshua's come back to say, if links are allowed, this is the LSB letter, which I think confirms the deadline extension for the new year. Thanks for that, Joshua. I'll pick that up and hopefully others will be able to as well. Let's just have a look. Anonymous has said, please can you kindly elaborate on FSCS limits in terms of business, the terms of business sent to client, and what is the limit and any necessary information? Well, you should already have things in there relating to the FSCS limit as it stands at the moment. But I'm just going to find my bits and pieces here. So the standard deposit protection is £120,000. So that's gone up from £85,000 to 120,000, and that's per eligible person per authorised firm. You've then got temporary high balances, and that's from major life events. So we're talking about selling home, inheritance, and that level has now gone up to 1.4 million. And that's protected for up to 6 months. So what you might want to do is pull off the slide and use that data. You might also want to go to the link at the bottom of that particular slide, where you can go to the article that I picked that up from, and you might find some more detail, or you will find some more detail there. But if you are still sort of concerned, then give us a call and we'll see what we can do to help. Okay, let's have a look. Margarita says, in terms of Lexel, our assessor must be quite strict. Well, that's good. That is really good. It may be, though, and I'm only surmising here because, as I say, they are restricted on time to try and keep costs down. It might be that they are actually doing what I would do if I was an assessor, and that is focus on the really important stuff. And the really important stuff at the moment is making sure you're complying with your financial crime aspects, money laundering, bribery, fraud, and all that sort of thing. And it may be that actually they're then focusing on that, but not focusing on other things. So it's just shifting the focus. So make sure the other things are where they need to be as well. It's one of the reasons why I'm really trying to push the Law Society to get this change, because we shouldn't need to be in this position where, you know, is it this, is it that? It should be, you know, it's properly assessed. If people are found to be wanting, then yes, by all means, you need to guide them in the right way. But when you've got people, firms, that have clearly been disciplined by the regulator for breaches up to 15 years, then doesn't that tell you something about the controls that you've got around your own accreditation? And, you know, does it then mean that we, you know, they then need to be sort of being harsher on sanctions? And, you know, I don't want people being sanctioned, but at the end of the day, if people aren't going to do what they're supposed to do, and what we need to remember, of course, is that, okay, following the regulations is not an option. Holding CQS and holding Lexel is an option. Firms have chosen to be held to the standards that those require. So surely, you know, they should be making sure that they're doing what they're supposed to do. And if they get sanctioned for not doing it, well, that's because they chose to put themselves on the line. So you might think, well, you know, it's been rather harsh here, but all I'm trying to do is protect firms. I'm trying to make sure that those people who are doing the right thing are in the right commercial position to compete over people that perhaps aren't. And it's also trying to, you know, get people doing the right things on an ongoing basis. One of the webinars, I didn't put it on the slide earlier on, but one of the webinars that I've got coming up in the new year is where were all the compliance officers? Because in all of these firms that have been fined and are continuing to be fined, there was a COLP, there was a COFA, there was an MLRO, there was an MLCO, there was an independent audit function, there was a senior responsible officer for Lexel and CQS, and ultimately there were the partners who are ultimately responsible for compliance. So where were all these people in those firms that were fined? Because if they were doing their job right, then surely they wouldn't have been fined. So it's going to be interesting, and I'm going to touch on those sorts of things in the webinar. So if you're interested in coming to that and getting my further thoughts on it, then please do. Let's have a look at anything else. Dun, 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 dun. Many thanks for everybody wishing me a nice Christmas. And again, thank you very much for your support. We seem to have run out of questions now, so I'm going to end things there. I don't think there's anything else just come in. Let me just make sure nothing slipped in there. No, I think that's it. So yeah, thanks very much indeed, everybody. Have a wonderful holiday, and I'll see you in January. Take care. And as always, do stay safe. Bye-bye.